Bid protest, compare and contrast. Chris, Massachusetts.
Am I up first?
Yes.
Yeah, okay, so one of the things that we were hoping to do tonight was to compare and contrast different positions on certain issues, including where Mass law differs from Rhode Island law. So we have a few tonight where we're trying to draw that comparison because we know a number of you deal in both jurisdictions. So Massachusetts, so what I want to do is I want to give an overview of Mass bid protest law. As a general proposition, it is a very easy, user-friendly system, one that is not expensive to access, one that has people with some expertise deciding the issues. The cost of entry of filing bid protest are low, and when you hear from Joe about Rhode Island bid protest procedure, you'll see that it is dramatically different than you have down in Rhode Island. So there are a couple basic choices. If you're going to bring a bid protest in Massachusetts, you can go straight to the Office of the Attorney General Bid Protest Unit, or you can proceed directly to Superior Court. Going to the OAG, Office of the Attorney General, is much less expensive, and it's usually the first step. The jurisdiction of the OAG over bid protests includes Chapter 149, Sections 44A through H, and of course it includes Chapter 30, 39M, Public Works Construction. It also includes some other things like designer selection and DCAM certification decisions. What are the basics of a bid protest before the OAG bid protest unit? It's easily commenced. All you have to do is send them a letter. Filing fee, I think it's $100, maybe $150. Nothing formal, doesn't have to be any formal legal brief or anything like that. Send them a letter, tell them what your complaint is, and you ask for a hearing. There's no strict time limit on when you have to file, although it's always better to file sooner than later, as soon as you know you have a problem. Don't wait. There is no discovery, for those who know that term. There's no depositions and interrogatories and all that kind of stuff. Hearings usually commence within 10 days. Very rarely does it take more than 10 days to get that hearing. The parties or their representatives usually are requested to submit something in writing ahead of time. No formal guidelines, doesn't have to be anything lengthy or anything, just a clear statement of what your complaint is. The hearings are informal. They rarely last more than a few hours. Any party can represent himself or herself. Anyone can attend. Anyone from the public can attend. That can be a little irksome at times. I've had bid protests where there have been people there who refuse to tell anybody, including the hearing officer, why they're there or who they represent, which struck me as a little bit unusual, and I objected to that. But Deborah Anderson, who hears the bid protest, said, no, we have no rule on that. Anybody can do it. They don't have to tell us who they represent. There is no stenographer or record of the proceedings. There's no formal testimony and questioning by lawyers. Basically, you turn to your, either the lawyer makes a statement about their case or might ask their client to have some comments. Rules of evidence don't apply. There's no objections to hearsay. There's no cross-examination. That can be very frustrating. Nothing worse for an attorney than to listen to somebody lying. You know they're lying. You know you could reduce them to tears if you had a chance to cross-examine, but they won't let you cross-examine. But that's part of the informal nature of it. You usually get a decision within a few weeks. Importantly, the awarding authority whose bid you protested will usually hold off on taking any action pending the decision of the Office of the Attorney General. But it is not required to. So if you ever bring a bid protest, you need to keep that in mind, which means you need to be prepared to run over to court if it's really important to you, just in case the awarding authority is not going to hold off. And you also try to make the awarding authority play their hand and let you know if they might act precipitously and before the OAG rules. Likewise, the awarding authority usually respects the decision of the OAG, but is not required to as well. And with increasing frequency does not do so. The comedy that used to exist in the OAG's office and the various awarding authorities has eroded over the years. You cannot be sure that because you have that OAG favorable bid decision that the authority is going to honor it, and you have to make sure to protect yourself. The bid protests cover any number of subjects. The standard of review is generally arbitrary, capricious, or involving fraud or bad faith. That's a common standard. Importantly, the OAG does not require that you file a bond in order to pursue your bid protest or to get a favorable ruling. Finally, there are a lot of bid protests filed every year. Many more so than Rhode Island. I did a count over the last 5 years. There were 171 bid protests total over 5 years. It averages 34 That's way more than Rhode Island. And then the bid protest decisions are also published on the OAG's website, so you can access them. They're searchable, not particularly easily searchable, but you can go and find out whether they've treated an issue before and how they ruled before. And then finally, regardless of what they decide, either party can go to court. If you go to court, Superior Court, the decision of the OAG has no force and effect whatsoever. It's not binding. Some courts will give it a little deference. Most will just say we're going to start over. Bottom line is you get fairly intelligent decisions, written decisions from the OAG, and you can rely on them, and you know it's a quick and fairly inexpensive process.
Thanks, Chris. Joe, your comments on Rhode Island bid protest?
Rhode Island is similar in some ways. There's two steps. All contracts originate from our Department of Administration, which has a chief purchasing officer. All bid protests are directed to him or her. So you file a written statement outlining your bid protest, what you think went wrong. Almost without a doubt, without an exception, and I've done this many times, they're rubber stamped. The chief purchasing officer confirms the award to whatever the awarding authority did. Almost without exception, again, you go to Superior Court in Rhode Island, you ask for a temporary restraining order, asking the court to stop the award of the contract. Again, you have to have a good reason. It used to be many years ago that, it was the low bid, low responsive bidder, which typically meant your number. If you were the low guy, you got the job. And they almost would not step beyond that boundary. However, about 25 years ago in Rhode Island, our Supreme Court changed the whole paradigm of bid protest. They allowed awarding authorities to start to consider your experience, your past background, any other problems you had. So these subjective factors start to weigh in. Without exception, every awarding authority in Rhode Island now puts that language saying, we can do what's in the best interest of the public. Which means if you're the low guy, I can reject you and I can take this guy over here, even though he's higher because of these reasons. Typically, that is given great deference. That's not flipped easily by, almost never by the chief purchasing officer. And our Superior Court judges typically ratify that. You really have to show some extenuating circumstances. Chris mentioned it, fraud, error of law, unlawful procurement. Those are very high standards. They almost never exist. I will tell you, I recently had some success on one where they literally, the chief purchasing officer counted something wrong, was brought to his attention. He said, no, I'm right. It went to the Superior Court, and the Superior Court said, you gotta be kidding me. The judge was thrilled to have one where he could flip it because they almost never get to do it. It's very hard to flip a bid protest in Rhode Island. To succeed on a bid protest in Rhode Island, you have to have some really high standards to meet.
So thank you. Any questions on bid protest in either Mass or Rhode Island? Yes.
How would you know if you were, say, you were involved with it? Say you were the second bidder, or the low bidder, and you're the second bidder. Would they be notified? How would you know? You would just never know what's going on.
You need, in Rhode Island, you need to be at the bid opening. And after the bids are opening, if you're not there, you can request to see all the bids. So when you see the bid, don't look at someone's number. Look to see if it's responsive. For example, if there's a requirement for a payment bond and it's not there, that's a flaw to the bid.
Right, no, I understand that part. My point
Jim,
is,
you're saying if somebody files a protest, are you going to be
if
told?
you were second bidder ended up with a job, how would we been notified that the low bidder was protesting?
No, not necessarily. That's the problem. If you have any question in your mind, frankly, in either Mass or Rhode Island about, even if you're the low bidder, whether you're going to get it, and if there's any kind of delay and you're not here, you ought to be picking up the phone. There's no formal requirement that I'm aware of in either jurisdiction. The awarding authority tell you if they're thinking about tossing your bid for any reason.
In your experience, or guys' experience, what is the most common reason for a protest? Is it really no bid bond, or didn't sign the bid, or is it something more serious than that? Doesn't add up?
There's a varying amount. But I will just go back one point, Jim, on that point you made. If you go to the Superior Court in Rhode Island, the judge is going to say to you, where is the low bidder? You can't just bring in the chief purchase order. Almost without exception, they say that person has a vested interest to be here. Put them on notice and bring them to the TRO hearing. So, I mean, that's my experience.
No, I agree with you. Jim, I understood you're concerned if you're the low bidder and suddenly somebody else gets awarded the bid, why weren't you told how to protect yourself? So there's a lot going on, and you got to watch yourself, watch what's going on.
Yes.
Deborah Leonard said you don't have to sign your bid bond. It's not a fatal flaw, so long because the surety actually had wanted you to have that so it wasn't a fatal flaw. Even though Dave's the moderator, Dave says that he argues with me against that.
You refer to a case that was decided, a bid
Well,
protest?
yeah, they say that you don't have to, if you make a mistake and you don't sign your bid bond, that's not, I always thought that's a signed document.
Yeah, I wouldn't count on that decision repeating itself.
We encourage signing bid bonds. Are there any other questions on this topic? Yes.
I was just wondering about the opposite of that. Does the law deal with bid withdrawals?
The what?
Bid withdrawals, where the low bidder wants to withdraw?
Yes, it does. What exactly would you like to know?
Just, I guess, how difficult it is and what the steps are, and how
Depends.
successful they are.
It depends on the jurisdiction. Rhode Island is tough in every aspect of bid protests, including if you make a mistake and you want to get out of your mistake. There are legal cases that say if it's a ministerial error, obvious on its face, like a mathematical error, that the awarding authority is required to let you out of your bid. Don't count on the Department of Administration Division of Purchases in Rhode Island from honoring that law. 9 times out of 10, they will require that you proceed. I had a client a few years ago that on a $5 million project made a $1 million bid mistake. It was obvious on the face, should have been let out of that bid. The division would not let it out. We were contesting it, and before it was decided, the client said, you know what, I think I can still make some money on this, and actually went forward and did it. But the state wasn't going to let the person out.
That's when your bid bond comes at risk, because if you post a bid bond and walk away, they're gonna call the bid bond in. And that 5 or 10% is out the door. You know, the bonding company's gonna have to pay it.
The Mass statute 44B says that if the bidder can show financial hardship, even if it is a mistake in reading the plans and specifications, if the variance between your low bid and the next low bid is significant enough that it presents financial hardship, you typically in Mass can make the case that it was a mistake that should be excused or excusable in certain respects. I had a case recently where someone just basically misinterpreted the plans and specifications as they related to certain construction procedures having to do with the replacement of windows. The Mass awarding authority permitted relief, gave back the bid bond, did not penalize the bidder.
Thank you.